please, for rebuttal. Good morning. May it please the Court. Peter Greenspan, Jonathan Shapiro, and Mikhail Lopez on behalf of Mr. Gardner. This case, while there are a number of issues before the Court, really is one of trajectory from the time of the early motion to join that the Commonwealth filed and was granted in August, about 10 months before trial, right up through the conclusion of trial. By that I mean that we were presented with a situation where there was a joinder, which makes even more important the character witness testimony that was excluded because the Commonwealth was relying on propensity to commit crime, sexual misconduct, in two completely separate and unrelated incidents. And so that impacts the importance of the character testimony. And then, of course, the jury deliberation issues at the conclusion of the case where the court took partial verdicts which broke along the same incident lines, if you will. So the trajectory of the case starts out with the joinder issue. At the time, there had been no discovery in the case. The Commonwealth said that these cases were similar. Really, one relates to the other in that regard, even though the evidence from one case would never, ever have been able to be admitted in the other. By that, more specifically, the case, and we used initials throughout, the CK case, the thunderstorm case, was one in which Mr. Gardner was called into his daughter's room because she was afraid of the thunderstorm twice. CK says that on the second visit into the room, Mr. Gardner touches her in very specified ways over 45 minutes. The evidence from the slumber party, if that case, the CK case, had been tried alone, would never have been admissible because it only would have been propensity evidence as in the Commonwealth's case in chief. And really what carries through this whole joinder issue throughout the pretrial and fully through the trial aspects of this was the circumstances that Mr. Gardner was faced with defending other things other than the particular facts. And so CK says Mr. Gardner comes into the room and touches him. The other girls say that 2 nights later, or 30 hours later, that Mr. Gardner went into a different part of the house in completely different circumstances, was carrying a laundry basket around, multiple trips depending on which story between the two complainants that night. And so the circumstances were completely different. The CK evidence would not have been admissible in these slumber party matters had they been tried separately. So we're confronted very much with a situation where the propensity to commit a crime was the piling on aspect of matters by the Commonwealth at that point. There's an interesting sort of side note here. The judge who ruled on the original joinder motion, Judge Alper, we presented with her with a motion to reconsider a couple of weeks before trial because we had discovery at that point, and then a supplemental motion to reconsider within days because we had Brady evidence that came in at the last moment. And at that time, we were then confronted with a situation where the trial judge, Judge Kendrick, comes out knowing nothing about any of those issues. And Judge Kendrick, as the joinder issues were argued sort of over and over again, at that stage, before CK testified in the Commonwealth's case, it was renewed. At the motion to strike stage, a mistrial was requested because of that. Made quite clear that he was following the law of the case, essentially, doctrine, as opposed to his own decision, which he gave every indication he had concerns about Mr. Gardner being forced to testify and different matters there. So
Mr. Greenspan, yes, do I understand that your argument is not that each of the victims should have a separate trial, but the 2 days ought to be separate? 2 days, that's correct. Right. The Thursday night or very early Friday morning, the thunderstorm should have been one trial, and then the two from the slumber party, as we referred to it, should have been a separate trial under the circumstances.
Counsel, under the connectedness test or the common scheme test, isn't it relevant that the offenses question occurred in the defendant's home?
The connectedness, I have trouble with the word, is an interesting issue because that argument was never made by the Commonwealth. It was never suggested by either of the trial judges, circuit court level judges, nor the Commonwealth in its briefing in the Court of Appeals or the response to our petition for appeal in this court. But the
Well, no, that's not exactly true, is it? Didn't the Commonwealth attorney in the case below argue connectedness or common scheme or plan, and then the trial court says, for all of the reasons articulated by the Commonwealth, I'm granting the motion?
Well, their only use of the word connectedness, as I recall, is in sort of tracking the words of the rules and the authority. They really sort of devolved or defaulted into it being a common scheme argument. And that's, they never claimed that it was common plan in the Kirkpatrick line of cases, where the evidence of one was necessary and the evidence of the other. And they were relying on it being idiosyncratic, even though there was nothing idiosyncratic about it. They literally never were making the argument or made an argument to the trial judges, either one of them, that there was a connectedness. Thatcher and Yardley were never cited in the circuit court. They were never cited in the Court of Appeals. They were never cited in this court until the Attorney General's office cited it in the most recent briefing. So the connectedness argument, to get back to your question, was never made until recently. But even so, there is no connectedness. You have two incidents, the subject of which is sexual abuse. That's the allegation. But there's no connectedness, and there are distinct differences between the conduct on the thunderstorm incident and the slumber party incidents. So we've struggled to try to find a connection just to be able to respond to the argument, but there's not. But there's a lot of differences. Mr. Gardner is called into the room by his daughter twice on the first incident. He lies down on the floor next to his daughter first.
I hate to interrupt you again, counsel, but the Court of Appeals cites Yellerdy in its opinion and Thatcher. Both are connectedness cases.
But not the Commonwealth. I think I said the Commonwealth has not made had not made those arguments in any sort of affirmative manner that there was a connectedness of the evidence. So the connectedness of the evidence would go to the planning type of the situation, the Kirkpatrick line of cases. I think Kirkpatrick is cited in Thatcher, as a matter of fact, and where one leads to the other, where there is a frenzy that makes this all connected in some fashion or another. But also note that in Thatcher, then Justice, and not yet Chief Justice himself, filed a strong dissent in Thatcher, saying that the court had really blended in this connectedness argument. In that case, common scheme and plan and connectedness, contrary to all the prior precedents from this court.
Counsel, how do you distinguish Yellerdy? And I'm quoting, such facts connect the two events in time, place, and manner of commission.
Sure.
And we're looking at an abuse of discretion standard, and we've got time, place, and manner of commission here.
When you look at the facts specifically, I would respectfully suggest that you don't. They're separated by 30 hours. That in and of itself...
4 days in Yellerdy.
I was going to say, that in and of itself is what it is.
Place?
Place is interesting because there's place all within the Gardner, both instances within the Gardner house, single-family home in Falls Church, but different parts of the house and under different circumstances. So the place, given the place in the house and the circumstances within the house, real important.
You haven't convinced me yet. Let's go to method of commission.
May I just address place briefly? The place is Mr. Gardner was called into the room on the first instance, and that's not what the evidence was.
But that's not place.
Sorry?
That's not place. That's the reason why he entered the room.
Well, I think that it is. Place has to do with physical, certainly, but it's how you get to that physical location, what the nature of it is. It's on the top floor of the house, but he's called into the room by his daughter, versus being in the basement and going to the basement to the slumber party area independently. But Mr. Gardner didn't
Let's look
know...
at the third prong, manner of commission.
Didn't know that CK was even in the room on the first incident. As far as the manner of commission is concerned, the evidence would be that Mr. Gardner affirmatively placed himself in the basement and touched these two girls by looking at the evidence in the Commonwealth's favor at that point, that he was an affirmative actor. But that's no different than being an affirmative bank robber or bike path rapist like in Satcher or Yardley, as opposed to what you have here, which are quite different circumstances, and there are other distinguishing factors as well. But so that you have the manner of the commission of the offense is completely different. It is affirmative as to the slumber party incident as opposed to being brought into the room on the first incident.
What if we go beyond him being brought into the room and what happens after he's in the room? First time he's called into the room, thunderstorm. Second time called into the room, thunderstorm. But according to the testimony of C.K., the second time he deliberately places himself beside C.K. as opposed to beside his daughter. The manner of commission of the crime, according to C.K., they're playing a lightning transfer game, which then allows for reasons to say why he was, if he was, why he was actually touching the young lady. Same type of comforting, if you will, by one of the witnesses in the basement of he's tucking my sheets under my mattress.
Right.
And so manner of commission, the comforting aspect of that's why I'm in there.
Well, on the first instance, and there was not a verdict in the Commonwealth's favor in the C.K. case.
Well, we're talking about why they were joined.
If you look at the exhibits, it was an impossibility for him to have laid there as that was. And so that's why it becomes, as she described, that's why it becomes even that much more of a propensity.
But we're talking about the
situation.
joinder.
Sure, but that's why it becomes a propensity type or joinder type of an issue there, because the trial court never considered the facts as far as that joinder is concerned. As far as in the basement, beyond that initial tucking in of the feet that you described, there is the bold affirmative movement of going around the couch to the other gal, MG, and no comforting type conduct. And then the 4 additional times as far as CR is concerned of going right there and touching in the genital area without any sort of comforting. CK, the first night incident, describes it as being 45 minutes. The others are brief touchings. She describes it as being in her chest, her abdomen, her vaginal area. She later describes it as being in her rear area as well, back and forth and in a very patterned fashion, which is all inconsistent with what occurs otherwise. And I'm going to have to rely on our brief, which describes the discrepancies significantly as far as those issues are concerned. I'd like to address, if I could, the character evidence, which is all that much more important because of the joinder. So if we're wrong about the joinder, then the character evidence is that much more important. This court has always found character evidence to be significant, to be important, and to be able to be submitted. And here we were attempting vigorously to be able to put on evidence by a Justice Department lawyer, by some of the town official in the City of Falls Church, meaningful to that community, of no negative inference or indications as far as sexual misconduct or abuse or physical abuse. And that was cut off at its knees by the Commonwealth, aggressively stating, Judge, character evidence is only allowed for truth and veracity and honesty type of standards, which of course is just not Virginia law. It's now codified in the rules of evidence. Eventually, the Commonwealth seemed to concede that you could have some indications of no negative conduct in Mr. Gardner's past, but the trial judge refused to allow that under the circumstances, and it's candidly unclear why. He didn't say why he was refusing it. He just refused it. The Commonwealth continued to say, basically, Judge, it's just not allowed, or some suggestion about that the witnesses didn't know Mr. Gardner's reputation in birdsong and Barlow and so on, it's clear here that the testimony, by way of the actual testimony of the witnesses and our proffer, that they had a substantial base to know Mr. Gardner and as a character witnesses. I'm going to yield for the moment if I can. Thank you.
You've used all your time. Thank you.
Good morning. May it please the Court, I'm Benjamin Katz, appearing on behalf of the Commonwealth. I'd like to take up the joinder matter first, and I would note from the outset that the sole assignment of error as it relates to joinder is that the joinder of offenses was premised upon the absence of a common plan or scheme. It's the only argument in the assignment of error. And in making that argument, Gardner faults the Court of Appeals' recitation of facts found by the trial court, and specifically, I would identify page 85 in the Joint Appendix where the Court of Appeals recites that the trial court found the victims were all 9 or 10-year-old sleepover guests of E.G. The incident occurred late at night when it was dark, when the victims were sleeping. The incidents occurred when other members of the household were sleeping, and that the victims were touched in the same place. And that the facts found by the trial court are found at 1196 through 1198 of the Joint Appendix. And I would note, when the trial court made those findings upon the renewed objection to joinder, the defendant did not object to those findings. The defendant did not assign error to those findings in the Court of Appeals, nor did he assign error to the findings in this court. And I would argue, pursuant to Stevens, he's waived any argument in this court that the Court of Appeals erred in relying on those facts. And I would also assert that his exclusive focus upon the existence of a common plan or scheme is misplaced. Justice Powell, as you pointed out, the Court of Appeals' opinion recited the governing law as it related to both the connectedness prong and the common scheme or plan prong. In his reply brief, the defendant attempts to argue that the Commonwealth is precluded from arguing connectedness at this stage, and I would cite the court to Perry v. Commonwealth 270, Virginia 572, that an appellee may argue for the first time on appeal any legal ground in support of the judgment as long as it does not require new factual determinations. And Justice Powell, as you mentioned, the Commonwealth below clearly asserted the connectedness prong. It's clear in the transcript. I would say page 221 of the Joint Appendix for that. And simply put, the instant case is unlike Scott. We're not solely concerned with the common scheme or plan prong. Connectedness is at issue. And in attempting to distinguish the CK offense from the later June 18th offenses, Gardner focuses upon minute differences between. He notes that CK was not actually sleeping when the offense began. He contrasts the pattern of touching of CK with the multiple instances of Gardner's touching of CR and the penetration suffered by MG. And he argues that this difference establishes a dissimilarity between the offenses. And he further attempts to distinguish the defendant's words to CK during the offense, arguing he didn't speak to CR. And I would say that his focus in this regard and focusing on the minute differences is also misplaced. His effort to distinguish the variety of touching ignores the fact that the defendant was thwarted from penetrating CR simply by her presence of mind to demonstrate she was in fact awake. Moreover, as it regards speaking to the victims, he was only required to make the effort to speak to CK because she was in fact awake. CR and MG feigned sleep, and when CR demonstrated she was awake, it was at that point that he asked if she was okay. I would say that the tight focus upon these small differences seeks to obscure the larger picture that demonstrates their commonalities, rendering them connected. The touching of CK and that of CR and MG were joined by time, place, and the means of commission consistent with Satcher and Yellerdy. All of the offenses occurred under the defendant's own roof on consecutive nights. There can be no debate as to the union of time and place. And the purported distinctions that Mr. Gardner relies upon don't diminish the fact that he employed the same means to commit each offense. The victims were all targets of opportunity, brought to the defendant's house through their friendship with his daughter. He took advantage of the lateness of the hour at a time when they were most vulnerable. And regardless of the presence of others nearby who could come to their aid, in each instance, their confusion and their fear over the very shocking exposure and unexpected nature of Gardner's predation served to render them helpless. They could not call for aid. And the means of commission was the same in each offense. Regardless of the distinct ways once the offense was committed, he touched them. They were joined by a means of commission. I would argue under those facts, it can't be said that no judge would have found as the trial judge did. There can be no abuse of discretion in this instance. The offenses were clearly connected. As to the common scheme, I would simply rely on my brief for my arguments in support of that.
Counsel, could you address the character evidence?
Please, thank you, Your Honor. I would note the defendant argues a distinction between what he actually proffered through Ombrent and Allen and what he intended to offer. And he argues that the difference between what he intended and what was actually proffered amount to semantical subtleties. Mm-hmm. And I would argue that, in fact, the gap between the two represents the very difference between that which was inadmissible and that which is admissible. The first part of his proffer, and if I may, I would...
Let's back up to his first question. His first question was, do you know if Mr. Gardner's reputation is among those who know him well for being someone who would be a good caretaker of children as opposed to someone who would harm or abuse or be neglectful of them? Is that not proper character evidence?
And, Your Honor, I believe that is the part that the actual question to Ms. Ombrent, if that's what Your Honor is referring to,
right,
is the one that was not properly rooted in time prior to the offense. And so for that reason, the objection was sustained. And so then all we are left with is the actual proffer that comes from the defense itself, not from the mouths of Ombrent or Allen. And with the Court's indulgence...
Can I stop you just for a second? So you're saying the only problem with that question is that it didn't say before this incident?
That's correct. It was not rooted in the appropriate time, and for that reason, it is inadmissible.
But that wasn't the objection at that time, was it?
I believe it was, Your Honor, but with the Court's indulgence, if I could cite...
1768.
I believe on 1773, Your Honor, is the objection where the Commonwealth argues the proffer failed to address the defendant's reputation at the time of the incident.
I know, but the objection at the moment the question was asked was, Your Honor, his reputation for truthfulness and veracity.
And I believe thereafter a discussion followed between counsel, the Commonwealth, and the Court as to whether that objection was appropriate or whether it was admissible upon some other grounds, and I believe the Court ultimately sustained the objection upon the Commonwealth's later argument that it had to reflect the appropriate time. I don't think when the Commonwealth made the initial argument that Your Honor is addressing, the Court had not ruled at that point, and further argument followed.
So is that why the Court didn't let it in, because it didn't reference the appropriate time frame, ultimately?
I think that is a reasonable inference to draw upon this record, and that's clearly what the Court of Appeals found. And I would argue that it was not an abuse of discretion upon that basis to keep that testimony out.
I'm not aware of any cases that actually require that the question be asked with regard to a specific time. I mean, character, by definition, is something that is developed over time. And evidence of good character 2 weeks after the event is certainly probative of what his character might have been 2 weeks before the event. I mean, just by definition, that's what character is all about. I know of no cases that support the theory of the Commonwealth, and I have a pretty good common sense idea that character is something is broader than just an instant.
I appreciate Your Honor's question. I think there's a distinction to be made between character for truthfulness and veracity and character for a specific trait. And where it relates to truthfulness and veracity, of course, it wouldn't matter at any time prior to trial, but even after the event, it would be relevant as to the character for truthfulness and veracity. But where it relates to the specific trait that's at issue in the trial, it must be prior to the offense. Otherwise, it's irrelevant. And, Your Honor, for that proposition, I would cite this Court. There is an older precedent, Ginger v. Commonwealth, 137 Virginia 811, a case from 1923. More recently cited in Gravely v. Commonwealth, a Court of Appeals case, 13 Virginia Ave. 560. That's a case from 1992. So there is a distinction to be made where it's character for truthfulness and veracity, which does not matter at any time prior to trial, versus character for the specific trait at issue where it must be relevant to the time of the event prior to that time, because that is the reputation that matters for the testimony being offered.
Wouldn't that go to the weight of it as opposed to the admissibility? I mean, if you have a character trait on Monday, do you not have it on Friday? If you have it last year, do you not have it this year? I mean, I don't understand that. Why wouldn't it go to the weight as opposed to the admissibility?
Your Honor, I believe the jurisprudence indicates that is a question, a threshold question of admissibility, and where it seeks to go beyond that time is simply not admissible under the prior case law of the Commonwealth.
Yeah, the Court of Appeals has a case, Birdsong versus Commonwealth, which seems to take the opposite position from what you're taking. Can you help me with that?
Yes, Your Honor. As it relates to Birdsong, I believe the testimony in that case was negative reputation testimony, the absence of evidence of that character trait in the community at a time prior to the offense. And so I would distinguish from this case, and if I may back us up for a minute to get us reoriented in time, we're talking now about the proffer, not Ms. Ohnbrandt's testimony, or to the extent it was adopted from Ms. Allen, but the later proffer.
Honestly, I thought we were talking about the question, not the proffer. We haven't gotten to the proffer yet, have we?
Fair enough, Your Honor. Well, to the extent we're talking about the question alone, we're not talking about the appropriate time period.
Let me answer this, Mr. Katz, not to interrupt your two other questions, but the judge never gave another opportunity to rephrase that question, did he?
Well, I would submit the judge objected, and there was no opportunity taken to rephrase a permissible question for the witness.
Well, first he rejected it for the wrong reason, and then he rejected it for a reason that you think is correct, but he never gave him a chance to rephrase it. He said, let's move on.
Respectfully, Your Honor, I would characterize the exchange in the trial court differently. I think the Commonwealth asserted an incorrect reason.
Okay.
Further argument on that point, ably made by defense counsel, reoriented the court as to what the appropriate standard was. And at that point, the court said, this is not admissible. You've got the wrong... The argument was this is not the right time period. The court made a ruling, and rather than frame an appropriate question that would lead to admissible testimony, at that point, a proffer was left to directly.
Well, but the proffer cured the time frame.
It did, Your Honor, but if we may move on to the proffer, I would submit the proffer was incorrect insofar as it focused improperly upon Ms. Ohnbrandt's experience or specific instances of conduct for neighbors that she was aware of without reference to the reputation within the community, and that is the difference between Birdsong and the instant case. In Birdsong, we had a witness who was prepared to testify that the defendant enjoyed no reputation for the character trait at issue within the community, and that was wrongly determined to be inadmissible. And Birdsong says, well, that was perfectly appropriate. She was talking about reputation in the community in the absence of this character evidence in issue. Here we have in the proffer Ms. Ohnbrandt saying that she herself is not aware, and then reference to specific instances of conduct she knows of neighbors who would let him be with their children. But we never have an argument made by defense counsel that would root that in any reputation. And he argues on appeal that was clearly his intent, that he was trying to establish some relation back to what his reputation in the community was, but that argument was not made to the trial court. And so presented with the argument that was actually made, I would submit the trial court did not abuse its discretion. We cannot say that no judge would have determined, as this judge did, that given what was actually argued, there was not enough of a nexus to what was the reputation within the community. We simply have one woman testifying to what she knows personally and specific instances of conduct as it relates to neighbors.
Counsel, let me ask you this, though. On page 1775, the court says, this is at line 12, and this is in response to a conversation with Mr. Greenspun, his reputation was among those people that she knows. That's what the reputation would be. There's been no incidents or knowledge on their part that he's ever done anything like this, basically. It seems like the judge understood that it was about reputation. It's 1775, line 12. Sure, Mr. Greenspun, why don't you give it to him? Save some time. Mr. Katz, he's got it for you if you want to. So it seems to me that the judge understood he was talking about reputation and not about a person, about a specific incident.
And, Your Honor, are you on...
1775, line 12.
Thank you.
And then the Commonwealth gets back into the time frame and information which we've already addressed.
Your Honor, if I may distinguish the comments between 12 and 16, again, refer to reputation among the people she knows. And I would simply make a distinction between, to the extent Ms. Ohnbrandt was aware of his reputation within the people she knows versus the community at large. And I will acknowledge to Your Honor that is I'm slicing the onion very thinly there.
You are there.
But I would submit that there is a difference, and it is a material difference.
But you can't find the reputation of the community at large except by the people you know.
Well, and Your Honor, I would submit that perhaps that was the appropriate response to the trial court's observation. If the defense wished to make that point, that was the time to make it, to clearly indicate to the trial court that the people she knows are, in fact, the relevant community. And the trial court clearly thought there was a difference.
But the Commonwealth didn't make that response. The Commonwealth's response was back to at the time. He went back to at the time. So.
Thank you, Your Honor.
Okay.
I would simply argue that based upon this record, we can't say that the trial court abused its discretion.
Okay, thank you.
Can you tell me, I have one quick question. Can you tell me where in the record I will find the electronic data file introduced into evidence?
Your Honor, I would simply argue
No, just tell me in the record. Tell me a page number in the record where I will find that.
it is not for lack of looking, Your Honor.
Pardon?
It is not. I do not have a page number to give you, and it is not for lack of looking.
Okay, so it was not introduced into evidence.
I would simply argue that it followed...
Was it or wasn't it?
The electronic data file was created as a result of the analysis.
I know that. I'm trying to figure out where it is in the record. Was it admitted as evidence?
I understand Your Honor's question.
And the answer is no?
There is not a page in the record, but I would argue that it is a reasonable inference to follow from the evidence adduced at trial that it was created as a result of the analysis that Dr. Loyne made.
There's no question about that. That's what I'm worried about.
And it is part and parcel of the report that was admitted into evidence, that the two are the same.
Okay.
The electronic data file is the same information as what was contained in the report. It is a process of the scientific analysis of the DNA.
You've answered my question. Thank you.
Thank
Your
you.
time's expired. You used all yours in screen time. No, sir, I'm sorry. Everybody always wants 10 more seconds. Call the next case, please.